I don't find any relevance in it. It simply is somebody interested in riding along with the police. He did it once. He did it 2 years before the event. And I would suggest to the court that there's absolutely no relevance whatsoever to what he did as a rider with Sanford Police Department. And again, I know you don't want to go too far into the Martin side of it, but as to the Zimmerman side of it, certainly if information like this is going to be admissible, I think we're going to open up a panoply of information.
You keep telling me that we're going to open up different things, and right now I would like to keep focus on this exhibit, these 5 exhibits. If and when another argument comes up about something else, that's the time I'll listen to that argument.
But I just want to make sure the court's aware that I'm not waiving anything, because I want to make sure that, in my opinion,
I want to make sure that we focus on this issue. So your objection to 212, proposed exhibit 212, is relevance.
Yes, Your Honor.
Okay, response.
Your Honor, I actually have an argument prepared to go through that'll address all of them.
Okay, well then let's go on to the next exhibit. What is the number?
There is 211, which purports to be a business record from Prince William County Police Department. We would object on a number of hearsay grounds, and I understand it purports to be an unsigned letter with a acknowledgement, but it acknowledges that basically there is very little information available concerning Mr. Zimmerman's application, and then has some summary that suggests the reasons for it. In effect, what it seems to suggest is that Mrs. Zimmerman's application for that was not allowed because he had credit issues, because he was unemployed at the time.
What is your objection to this document?
Irrelevancy, and also that there's not proper foundation for authentication. And unfortunately, the problem that we have is this is sort of a summary of an exhibit that doesn't exist. So we would demand the actual application, the witnesses who reviewed the application, the more of a reason why, whether or not any interview occurred, not a summary from somebody who was not there and did not talk to Mrs. Zimmerman and actually hasn't even reviewed the application. So that's the authentication issue.
Okay. Next exhibit.
Seminole State College.
What's the exhibit
I'm sorry,
number?
I have my copy of this one. Give me just a moment, Your Honor. It is part of 209, Your Honor. So let's go through that because it's a composite exhibit. First one being entire transcript.
Actually, we had agreed yesterday.
Okay.
Only the 2 pages that we have submitted for redaction to the clerk is going to be part of that exhibit. The remainder of it, I agreed. After the court reviewed it and didn't want to consider other classwork, take it out.
Right. Do you have the redacted copy to show?
Well, we'll just take this out because this is the entire transcript.
Okay. I think that there's a redacted copy that you should probably
The
look
clerk
at.
provided it to me this morning.
It is not the redaction of the transcript. The transcript is removed completely. There's a redaction of another statement that I'll talk about in a moment.
Okay.
There is both the official transcript and sort of a summary. I think the state's acknowledging that both of those are removed from Exhibit 209. That leaves redacted 2 statements. One is a diploma certificate application, and one is an acknowledgement of a grade change in what the state perceives to be a relevant relevant class, criminal litigation. Again, the same argument as mentioned earlier, simply about the relevancy, both distant in time and no connection between my client's appearance at a course, or at least signing up for the course, and what actually would be presented to this court. And again, we request a proffer that information to see if the state can tie it together. Similarly, with 210, it is a...
You had said 209 was a composite. Were those the only things that were in the composite, those two documents?
Those two, yes, that's
Thank
all
you.
that's left.
So now you have 210.
Yes, and 210 is also a composite, so I need to go through those sort of individually. There is one that suggests that my client did a homework in a case dealing with such things as, I guess, answering your question, a man in his wife's absence drinks a lot, they get home,
There's scenarios.
there's scenarios, and none of these scenarios would have any relevance to anything, second-degree murder, self-defense,
So
any...
objection to that is relevancy,
Yes, Your Honor.
all right?
And
The other part of the composite?
then there is a final project from my client talking about the Fourth Amendment. Similar objection as far as relevancy unless it can be tied together. And a moment, Your Honor. The other part of this composite exhibit is an excerpt from a book on page 228, the book identified as Criminal Law and Procedure by a man by the name of James McCord and his wife, I guess, Sandra McCord. And this chapter 7 has about 3 pages on the term self-defense. Again, the relevancy without the connectivity between the state and the actual evidence. I think they may have the witness here. I would ask for a proffer to suggest that my client was even present rather than just having signed up for the course, and or that there was some discourse between my client and some witness acknowledging that he in fact did know about this or even read this. And then I presume that this is the same witness who may say that at some lecture, some point, he may have discussed or did discuss Florida Stand Your Ground issues. But again, without any particular relevance, the overall objection to these, again, being that it's sort of a 403. If there's no relevance, then the suggested relevance would be far outweighed by any prejudice, because I do not think that the jury should properly consider my client's past and his knowledge and what he may have known and what he studied. Again, for the issue that I mentioned earlier, that I think we're going down a very dangerous path for history. The last one is 201, which I believe is a same excerpt from another book for another class, for another professor, and that seems to be identified. I look at page 196, which is one page on psychological or criminal profiling and geographical profiling. I'm sorry, it's actually one page?
It is one because the remainder of the next page talked about racial profiling, and I deliberately left that out.
So again, same relevance argument, unless the state can present that my client had this book, got this book, read this book, interacted with the professor about this book. I think it's purely speculative and would be dangerous for the jury to be asked to consider such evidence for whatever purpose, unless it's properly proffered to you, not only as to the theory of the case and how this would be relevant to that.
So your objection to 201 is relevance. Okay, thank you. Response?
And of course,
Oh, those were the 5 exhibits. So on Exhibit 212, your 212, 209, 210, 201, and I guess to some extent 211 are all relevancy. 211 is also authentication. 209 is distance and time, and those are the objections. State respond.
And also, of course, we would want a Richardson inquiry. We did receive these on June 21st in the middle of trial. So as to that.
Well, are those documents that were in the possession of your client?
No. No.
His handwritten homework assignments,
Absolutely
his
not.
application?
Absolutely
Well, they're
not.
his documents. He knew of them.
I'm sorry?
They're his documents. He knew of them. He wrote
sure.
the applications. He
I'm-
wrote the homework assignments.
And I'm certain that he wrote Valentine's in first grade, but he didn't keep them.
Okay. Let's stay on point. Mr. Manti?
Let me
Response?
address just a couple matters first. As Exhibit 201 goes, there is not just the profiling excerpt. There are also chapters on preparing for and presenting cases in court, strategies for excelling as a witness, and testifying under cross-examination. That is all as it relates to Exhibit 201. And I want to make sure that I'm also being clear that Exhibit, I believe it's 210, Yes, contains not two, but I think there are 3 homework assignments. The other one being a description of why the defendant is electing to take the course in the first place. I would also note as to 210 that at Mr. O'Mara's request, I have appended the entire course book to proposed Exhibit 210, although I had not originally done so. I don't know that they want that to be part of, if it is admitted, if they still want that to be part of it, but it is there for that reason. Let me start with the idea that we are here on a basic relevance objection. In order to be relevant, the state's, there are more than one theory of this case. There doesn't have to be married to only one theory. There are a number of matters which can be relevant for the jury's consideration, and the state isn't bound to only consider one possible thing or one possible theory. So to say that the state must, for some reason, tie things to a specific matter overstates what the actual law is as it relates to the concept of relevancy. In this case, the court has heard, and I believe will hear further, that part of the theory here is that the defendant's ambitions and frustrations are part of what's going on here. You don't get to consider each one of these things in a little vacuum. We sort of plowed some of this ground the last time we had this type of argument as it relates to his prior phone calls to the non-emergency number, beginning with his creation of the Neighborhood Watch program and for the 6 months thereafter between that and the shooting. I'm going to give a few examples of what we've already heard as far as this trial is. Neighborhood Watch training, his argument that this shows care of the community versus a counter-argument that it could be seen as simply him wanting to play police. He has had a desire to be an actual police officer, and I will point out that Mr. O'Mara has on a number of occasions, and so has Mr. West, cross-examined various people, including Officer Tony Raimondo, about when they decided to become a police officer, why they decided to become a police officer, what they had to do that, and their motivations, and the fact that police officer is, in fact, a noble calling, a good thing. So I think they've already sort of made the idea about becoming a police officer and how strongly that motivates people and that sort of thing relevant by their own questioning. I think the fact of the college coursework is these are courses the defendant elected to take in pursuance of his legal studies criminal justice degree. The relevance of the application for the degree is that he submitted that application in the fall of 2011, and it indicates on his face that he wanted the degree to be conferred after he finished taking more courses in the spring term of 2012. The spring term of 2012. His coursework, at least some of these, already has focused on criminal justice and police issues. His extracurricular life sort of mirrored that interest, that desire that he has stated in a number of forums. The Neighborhood Watch, the parking committee, the calls and reports, and again, despite his vigilance in the community, what resulted in the arrest of a burglar in that community was the Stucco Man. He profiles and does follow, and profiling used in the sense that it is a investigatory type tool. He speaks, especially in his written statement so far, in written police jargon. And he tells Officer Serino, well, you have justifiable use of force or homicide. He indicates that. And he also, in that the written statement he made for the police, he uses such phrases as, I unholstered my firearm, not I pulled my gun. So the idea that we haven't already heard things about this to make this prior history and prior training as to why these sorts of things are out there is indeed relevant. And I'm going to talk about general relevance, but I want to go through some of the things that we've already heard in this case as to why these things are relevant. And then we heard the cross-examination of Detective Serino, where we had umpteen mentions of this is a police tactic. I think whether the defendant would have knowledge of it or knowledge of the law itself was brought up. As I said, part of the video that was played for the court, he referenced self-defense or justifiable homicide versus homicide. I think Mr. O'Mara actually said, I'm not trying to discuss trade secrets, but that's the phrase he used. So anytime we're talking about the defendant and tactics being used upon him, I think his knowledge that they were in fact tactics or potentially tactics and his ability to understand the context of a criminal investigation and B, criminal litigation, and those are the titles of the two courses in question, is certainly relevant. I'm going to point out that jury instruction 7.4, this goes back to my point about nothing exists in a vacuum, is an act is a series of related actions. Its relevance shows why the defendant took a particular series of steps, exhibited certain behavior or attitude. 90.401 and 402 define the burden of relevance. It's anything tending to prove or disprove any material fact. It doesn't have to be a specific notion of or theory. It doesn't have to be, it can be. Anything that's material fact. Also, relevance has been defined as a tendency, and here I'm going to go into the cop show case, which is the first case in the stack that I provided to the court and counsel. Render a proposition and issue more or less probable. To be probable, the evidence gets viewed in the light of logic, experience, and accepted assumptions concerning human behavior. In the cop show case, the defense argued a state of emotional distress, which led to the killing. Therefore, they have placed the defendant's emotional state in issue, said the court. And in this case, the evidence in question was an affair that the defendant, cop show, was having. Not a, I'm sorry, that's KOPSHO.
Thank you.
It's 84 Southern 3rd 204, and I'm going to put the site up on the screen in just a moment. And the record here supported, and the court approved and admitted that the evidence of this affair was probative of the emotional state and the credibility of the defendant. I will also point out that on page 8 of that opinion, at the very top, the court discusses that this was put in issue by the defense's second-degree murder theory, and the state also argued that the evidence was relevant to impeach cop show's videotaped statement. So we have a number of purposes for which this is relevant. This isn't impeachment about something merely collateral. It is simply a fact that the jury ought to know. When they hear one assertion on videotape, they deserve to hear the rest of the story. Relevance can pertain to any of the elements of the crime. The defendant's state of mind here, the ill will, the spite, is an element of the crime. That is documented in the Wimberly and Hart cases, which are the next two cases in the stack that I've provided to the court. Relevance can pertain to any element of any defense. The state also in this case has the burden to establish that this is not a self-defense case, and that includes whether the defendant might have provoked the incidents, or to use the phrase in the Billode case, which is 578 Southern 2nd 343, that's Billeaud as indicated on the screen. The theory in that case, and I'm reading from the bottom of page 2, tended to prove a material fact central to the appellant's, in this case it was the defendant wanting to introduce this, that it was the straw that broke the camel's back. This particular camel, if we stick with that metaphor, has been carrying an ambition or a desire to be a police officer and to act in certain ways and behave in certain ways, and I think that's relevant to explain his behavior on the night in question, or at least assist the jury in having a fuller depiction. As far as being relevant to theory of the case, it can show the context of the defendant's behavior. This is a segue into the Holmes case, which we discussed pretty extensively before, which is 91 Southern 3rd 859. It's the next case in the stack. Continuing chain of, and I'm reading from page 3, continuing chain of chronological events. And even though it was prejudicial, almost all evidence introduced by the state is prejudicial to the defense. Credibility is at the heart of the case, and it prevents the state from fairly and adequately making the case against the appellant if the evidence is excluded. In that case, it was evidence of drug dealing. Morjon is a similar thing, and that can be found on 394 Southern 2nd 1100. Also on page 2, and also, again, evidence of even actually other not-so-good activities. The state isn't asserting that these are bad acts. The state is simply asserting that these are acts by the defendant and things that he has elected to do, which are relevant to help the jury understand his actions on the night in question. Continuing on the point about theory of the case, in the Samuels case, which is 11 Southern 3rd 413, the next case in the stack, and I'm going to read, I think, beginning on page 3 at the bottom, starting around head note 8. The court in that case admitted a couple different things. First, They admitted evidence that the defendant hid assets in the Cayman Islands in other people's names, and that was relevant to the state's theory of the case. In that case, the state was proceeding on the theory that the defendant committed murder because he didn't want to have to pay child support, and he was hiding assets to do that. Second thing the court admitted was documents from the child custody case that were relevant to the state's theory that the shootings were the culmination, in that case, of an ongoing battle. Again, we're back to the sort of straw that broke the camel's back type scenario. And that citation, again, is 11 Southern 3rd, 413, Samuels. Familiarity, and we may hear this again as it relates to other evidence, but evidence that shows familiarity with or proficiency in certain tactics. In the Marquard case, that's M-A-R-Q-U-A-R-D versus state, it was martial arts and military tactics. But familiarity with tactics, police tactics in this case, is not by itself evidence of bad character, nor is it similar fact evidence of another crime. It's just relevant evidence. Familiarity, in fact, can be a valid reason for a lot of things that wouldn't ordinarily necessarily be admissible. And this is the Rhodes case, which should be the next one in the case, and I'm reading page 9 of 11 of the court's copy, 638 Southern 2nd, 920. In that case, the court held that evidence of actually the defendant in that case being familiar with police procedures because he'd been arrested before several times was familiar, and in that case, to show that he'd voluntarily waived his Miranda rights. So the idea that someone is familiar with police procedures is not an unheard of or uncommon concept in the history of the law, and it's not something that's necessarily inadmissible for any reason. In fact, it's been admissible for, I would submit, far more significant and serious reasons. You're talking about now here supporting the idea of whether somebody waived their Miranda rights. Moving on from theory of the case for a moment, if it is relevant to other facts in issue in a case, any fact in issue, the defendant's motive, defendant's state of mind as to whether he's profiling or not, according, again, referring to the Hart case, those are classic jury issues. Defendant in his opening statement portrayed himself as simply a concerned neighborhood individual, and there's a question about whether he was concerned or exhibited hostility. Did he observe or did he profile? The impact, and I'm going to move on to the next case in the stack, which should be Eugene versus State, which is 53 Southern 3rd, 1104, and I'm reading from page 4 of that opinion. In that case, the evidence in question, and they were statements and emails that the defendant received, showed they were relevant to show the sudden deterioration of his relationship with the victim, demonstrate their impact on the appellant. And so it's the impact of these prior things that have gone on in his life that can be a fact in issue and is relevant. Other facts in issue. There was ample implication during cross-examination of these witnesses that he only followed Trayvon Martin, that the defendant only followed Trayvon Martin. And this is in the cross-examination of Mr. Nofke, that there was some kind of supposed suggestion in how he interpreted the words. I think the testimony of even Mr. Osterman yesterday sort of indicated, well, I think maybe he just interpreted it some way, but here's what he said. So actually, whether or not the defendant knows better or would have any reason to know better is relevant. Cross-examination, again, Mr. O'Mara's cross-examination of Detective Serino about the trade secrets sort of thing. The statements in the interview, especially his written statement. The idea that he has been exposed to materials on and taken a course that covered how to be a good witness. And this is all, again, the coursework intertwined with the other evidence of his ambition and his activity. And not that there's anything wrong with that ambition, but it certainly goes to the defendant's state of mind. He has applied to be a police officer before. He still wants to be one, according to some of his homework assignments. The homework assignments are relevant because that's the sort of thing that he did in the class. He was involved. This isn't sort of some passive non-thing, especially the one that tells you why he wants to take in the class in the first place. The idea that he wants to go right along with police, that he wants to be an affirmative participant in what's going on. Again, not that it's bad, but it's relevant. I will also point out that there is a relevance as to the defendant's particular knowledge. The state argued in a case as part of its identification theory, and I'm now on to the Williamson case, which I think is the next one, that the evidence demonstrated in that the gunman had knowledge of legal forms. The killer in that case had legal forms. And as proof, the state sought to submit that the defendant had actually filled out and knew how to fill out other legal forms. And the court held that that was admissible, relevant to the issue of, in that case, the identity. And they agreed that the introduction was not 90.403 material. And I will point out, I want to address 403 for just a moment. Rule 403 says the danger of unfair prejudice must substantially outweigh any probative value. I have yet to hear how any of these documents are supposedly prejudicial, let alone unfairly prejudicial to the defendant to that kind of degree. They have asserted none. They are clearly probative of his experience, his desires, his state of mind as of the time of this killing. And so, Your Honor, as it relates to each exhibit in particular, State's Exhibit 209, which is simply the fact that he had completed enough coursework to be applying for a degree at the very term that he would have been completing when this homicide occurred. Two of the particular courses he took, criminal investigation and criminal litigation, which bear in a number of ways on his behavior in this particular incident, as well as his behavior in other contexts, and the fact that he would know, there's nothing secret about this. The idea is that he, if he were ever involved in this kind of situation, he would know what there might be asked of him, done with certain pieces of evidence, what he might be asked about, the type of questions or the way that they might be asked. He would know these things, or at least would have reason to know these things. Again, as it relates to the prior application for the police force, as well as the application to ride along with the Sanford police force, it shows his continuing involvement, and this is over a period of time. This is not some Johnny-come-lately to this idea. This is a person who has decided that he wants to not only do this, but he wants to receive a degree in it. And there's nothing wrong with any of that, but it certainly tells us a little bit about the defendant's state of mind when he encountered this individual that he automatically, the first words out of his mouth were, a suspicious guy. So the state believes that all those 5 exhibits are relevant for not just one reason, but a number of them. None of them are conceivably more prejudicial than they are probative. And we've made efforts to redact the personal information so none of that would get out. There's
none of the bad credit or any type of good credit or any personal information that would...
The personal information we took I screened it first, I asked the defense to screen it too, and the clerk finished the job, and I think between us we pretty much have got everything. The thing that Mr. O'Mara referred to was a summary as to why the application was denied, which does cite COLL credit history. If that would need to be redacted. I'm fine if the defense wants that. Again, if they want to avoid the implication that he was denied for any other reason, I understand that as well. So it is there, but I have no objection if that particular part of it gets redacted. And as far as the authentication of it, it is the letter actually, the research was done.
Just for the record, that's part of 209. No,
I'm
that's
sorry,
part of 211.
It's part of 211, Your Honor. The letter in question and the research was done by Lieutenant Scott Kearns of the Prince William, Virginia Police, and he is the witness who would be testifying about it. They do not keep the full application for any more than their statutory required period, and so the record as to the application doesn't exist, but the record that he applied and was rejected does, because Lieutenant Kearns wrote the letter. As far as whether the defendant had to
I want to address the argument that he somehow we have to establish that he particularly knew about or was present in a certain class when a certain subject came up. I believe, again, that overstates the idea of relevance. The idea of relevance is that the defendant expressed an interest in this type of course. He paid for it. He took it. He was seeking a degree in it. And the notion that a college guy never misses a class, and one of them was even an online course where you'd have to interact in a chat board forum and things of that nature. The idea that you have to establish that he read a particular word in a book, I think, again, way overstates the idea of relevance here. The fact is he sought out and then, of course, had access to and was obliged to get a grade about. That he had to do all those things and that these were his choices. So I don't think the state has to necessarily prove that the professor put eyeballs on him and had him sitting in the seat in order to make his choice of course and the material that would be covered in that course relevant to the state's theory of the case.
Thank you. Mr. O'Mara?
First of all, of course, we're calling this witness for some type of impeachment, but beyond that, Your Honor, having just been given 10 or 12 cases from the state, I would ask for a couple of hours to actually,
Sir, I gave you all night last night and a half hour yesterday, and I told both sides I understood your arguments, and I needed you to be prepared to come with the case law to support your arguments. So
may I finish my request? May I finish my request? So
may
it's
I
on the
finish?
record?
I will let you finish, of course. The purpose of having this argument this morning at 8:30 was to give both sides the opportunity to provide to the court case law that would support their position. I have a jury sitting back there. This issue, I spent the night looking at it. Both parties spent the night looking at it. Let me hear your argument.
My request is for a continuance for a couple of hours because I've just been given about a dozen cases from the state that seem somewhat instructive to the court, but I've noticed already, just as Williamson and other cases, just in the moment I've looked at it here, that there are distinguished characteristics to those cases that I need to have an opportunity to present to the court. So, to the extent the court is going to rely at all on the state's argument and the case law that I have not had a chance to review, then I would ask for some time to do that on my client's behalf.
Well, again, Mr. O'Mara, in all due respect, we started this issue yesterday afternoon. I had the jury out for a half hour so you could have time to research this issue. You came back and told me that you needed overnight because it wasn't enough time. Recessed early yesterday, provided counsel for both sides overnight to research this issue, and I will listen to any cases that you have to support your position. But I'm not continuing this matter.
With that in mind, Your Honor, the state's cases to date seem to show, first of all, I would think that it is in fact a 404-2 argument because if in fact they are trying to bring in acts that they are then going to argue the relevancy to the jury, then they are in fact 404 attack on my client's credibility, and they can't slide past their requirement to give us notice of these prior acts 10 days before trial by suggesting, well, that they're not really bad acts. We're just going to argue that they're bad acts. Well, actually what they're going to argue is that they suggest, as the state has now acknowledged, that these acts somehow support their theory of defense for second-degree murder. So they can say to you that they're not really bad acts because they don't want to have a 404-2 analysis of it, but that's exactly why they're putting them in. They are putting them in so they can turn them into seething bad acts, subtle but seething bad acts of my client. So they can't color it one way to bypass 404-2 and then color it another way in their argument to the jury. If in fact they are going to argue to this jury that these are evidence of knowledge, of forethought, of knowledge which was the foundation for his ill will and hatred, that he had this available, then it is in fact a 404-2 analysis. They violated their requirement under the rule to give us 10 days notice ahead of time. That then demands a Richardson inquiry as to that issue. So in that sense, they can argue to you that it's not 404-2, but it in fact is. And let's look at why. The case law that they have suggested to you to date, today, is all, in effect, prior bad acts under 404-2. An affair to show anger and hostility towards a person, the wife, ex-wife he ended up killing. Hiding money in the Cayman Islands to avoid child support, a bad act to show what he was doing to presume the ongoing battle between the two. The sudden deterioration of the relationship between the defendant and the alleged victim. Again, the bad act information, 4042. What they're saying is, well, it doesn't look bad on its surface, Judge, so ignore 404, but we're going to argue that it's bad. We're going to argue that he was a seething cop wannabe and argue that to the jury. They can't slide, I would suggest to the court, they can't slide by the evidence code and suggest that this isn't exactly what they're going to do. So I would ask again that they somehow relate this to some theory of the case factually. What does the state say happened on the night of February 26th that makes this information relevant to prove a fact? Do they say that he ran after him? Do they say that he tracked him down? There's no evidence to support that, not to date, certainly, and I don't think that they're going to be presenting any more factual evidence in that regard. So in effect, what they're doing is trying to subtly present evidence through you, through this argument and your ruling, that they will then turn into 404B evidence to the court. And that's not allowable, which is why we have 403, to look at it and say what it is that they're trying to do and what purpose is. So if, in fact, they're going to bring in prior good acts of my client, which they can't do either, by the way, unless they show a connectivity, a relevance to some theory of their case, and I would again ask that they proffer both the theory and further they proffer the actual evidence, because it is still my position that if, in fact, they're going to say my client knew of stand your ground, and that's somehow impeachment, again, on, I believe, a collateral issue, an improper impeachment, but if they're going to say that as a foundation bringing in this evidence, then at least they should proffer it to you for you to make a primary or threshold determination that this is, in fact, relevant evidence, that he was in the class, that he did know about it. What they're doing, and I was only half kidding when I said Valentine's in first grade. There's an enormous amount of information that we carry on with us as adults. But we're not held to know it completely and fully in a criminal courtroom in a second-degree murder case unless you can connect those dots, unless you can say without question, yes. In all of the cases, including Williamson, that I just had a chance to look at, the court looked at it and said, as to that particular issue, where they connected up, this form he filled out is very relevant to this fact, and there is a connection, we will allow it. The problem here is that we do not have any connection. We do not have any from the state. We have great argument that their theory is he wants to be a cop. And somehow, the fact that he wants to be a cop and actually went to a class, we should be able to argue that he wants to be a cop. Well, if in fact they're going to limit themselves before you, that they're only going to argue he wants to be a cop, then it's not relevant. If in fact what they're going to try and argue is he's a seething cop wannabe, then they have to show that there's a connectivity between the two to make it relevant, and they failed to. And I renew my request for the proffer of the evidence so we can see actually what these professors are going to say before a jury hears it, because if in fact it gets to the jury, we can unring that bell. And again, request more additional time to address this.
Okay, thank you very much. Did you have something further you wanted to say?
If I could, Your Honor, I just want to refer back to two cases, and that's Marquardt and Holmes, and I'll quote briefly from Marquardt. Evidence showing familiarity with or proficiency in tactics is not by itself evidence of bad character, nor is it similar fact evidence of another crime. In that case, again, that was the martial arts type tactics. So, and Holmes, of course, we covered very extensively when we covered, but this is inextricably intertwined evidence to various things. As far as proffering the evidence, well, I videotaped one of the professors and gave the defense that. As far as a Richardson inquiry goes, they've had certainly access to all the college materials and everything else. They've had the records custodian and his transcripts and everything else have been listed for months. In fact, the defense was so on notice of all this stuff that they filed a motion in limine before this court seeking to exclude any mention of the phrase wannabe cop or anything like that. So to now come in and say, oh, we're surprised by all of this, we have no idea, these people have been listed for a long time. The only exception to that, really, is the homework assignments that when I followed up with Professor Jackson, he provided, it was either a week or a week and a half ago, somewhere around that, and I provided them the day I got them. That's really the only thing that hasn't been, and I will point out, Professor Jackson's been listed for quite some time and has never been elected to be deposed. So I simply say that the effort here to now, and I'm glad I brought the picture along, is being, as we expected, to try to shoehorn this from 401, 402 to relevance to 403, more prejudicial and probative, to now we're at 404. And what that tells me is that the defense doesn't really know what the proper objection is because there isn't one.
Okay, thank you. I have reviewed the evidence code, I've reviewed case law, and after listening to the arguments by the counsel today, the court makes a determination that the testimony bears directly on an issue in this case, therefore testimony is substantive and the objections are overruled. Do you need a few minutes to get your first witness ready?
There was an issue regarding the redaction of the police
Credit.
application.
As well as I just needed to know whether the course book still you want that included or not.
The concern with the redaction, Your Honor, is though it is distasteful to have that information before the jury, taking it out will simply allow speculation that there was some other reason why, rather than just the fact that he had bad credit. So in the Hobson's choice of having to allow the jury to know that my client had bad credit, which I think is completely inappropriate.
Does it say the words bad
Yes.
credit? What if we just took out bad and just put
Let me
credit?
add one other to this. The lieutenant will say that that is the reason that was listed, and that could mean one of two things. It could mean there was in fact a credit problem, and it could mean that the defendant was not candid about his credit reporting. Either one of those I don't think is an inference the defense wants drawn, but I'll defer to their wishes on that.
I'm in a Hobson's choice. I need to decide
Well,
between.
what if we took out the word bad and just put credit as an issue and left it there?
It says the same thing to the jury. Your Honor. I mean,
Could be they weren't able to verify the credit, doesn't mean it's bad or good or indifferent.
Actually, if they want to strike the whole last page of it, that's
Oh,
also
well,
fine.
There you go, then the last page will be stricken.
I have a
Issue
moment to review it.
not an issue. They're figuring that out. We'll take a 10-minute recess. Court will be back in 10 minutes. Thank you very much. State, you may call your next witness.
Thank you, Your Honor. State would call Sonia Bowles-Melvin.
Do you solemnly swear or affirm that the testimony you shall present will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
You may proceed.
Thank you, Your Honor. Ma'am, please do me a favor. Spell your name for us and tell us who you are, where you work, and what you do.
Sure. My name is Sonia M. Bowles-Melvin. It is spelled SONJA-BOLES-MELVIN, and I am the registrar for Seminole State College of Florida.
What is a registrar?
The registrar is responsible for all of the educational records, academic records of the institution.
And I assume that your institution keeps academic and institutional records.
Correct.
I'll show you what has been marked as State's Exhibit 209 for purposes of this proceeding. Do you recognize that document?
I do.
And is that the type of record that is ordinarily kept in the course of your institution's business?
Yes.
And does it pertain particularly to the defendant, in this case, George Zimmerman?
Yes.
Now, there are two sort of sections along with this. I may, Your Honor? The first is what I'll call a grade change form. You see that?
I do.
Okay. And this was actually submitted for a particular course in a particular department. What is that department, ma'am?
It is legal studies,
Okay. And it is course of which title?
criminal litigation.
Okay. And the second is a diploma or certificate application, also in the name of the defendant. Can you tell me, is this something that, when would a person fill out a form like this?
When they are ready to be awarded a degree from Seminole State College.
So they fill this out to ask to apply for a degree?
Correct.
Right. And tell me when, A, when this form was filled out, and B, if you can tell, when the degree was actually supposedly going to be conferred or was being requested for.
Okay, it looks like Mr. Zimmerman applied for graduation during the term fall, which would have been our fall commencement. And he applied on October 17, 2011.
Okay, so that was when he submitted the application. Does it tell us when he was requesting or thought he would have the degree?
Yes, he thought he would graduate by spring 2012.
Okay. Thank you, ma'am. No other questions, Your Honor.
Thank you, Cross.
No, thank you very much.
May Ms. Bowles-Melvin be excused?
Yes, Your Honor, thank you.
Thank you very much, ma'am. You are excused.
And I would move at this time States Exhibit 209 into
Based upon the court's ruling, it's submitted into evidence as State's Exhibit 209.
Scott Kearns?
Thank you very much.
Do you solemnly swear or affirm that the testimony you shall present will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
May I proceed?
Thank you, Your Honor. Morning, sir.
Morning.
Would you please go ahead and spell your name for us? Tell us who you are, where you work, and what you do.
Lieutenant Scott Kearns, Prince William County Police. Last name spelled Kearns, first name Scott. I'm currently assigned to operations, Prince William County Police, Prince William County Police, and prior to that I was the bureau commander for the Prince William County Police Personnel Unit.
Okay. Prince William County where, sir?
In Virginia, sir.
Okay. And does the Prince William County, is there a particular name of that agency? Are you the city police, the county police? What?
It would be county police.
And does that agency normally keep records of people who apply for jobs in that agency?
Yes, sir.
Jobs, both civilian and as a police officer?
With the police department, yes, sir.
And in your capacity as the manager of the personnel unit, would you be the person who would normally be, I'll call a custodian of records of that type?
Yes, sir.
How long does the Prince William County Police Department keep the actual applications of records?
Well, in accordance with the
Thank you.
Virginia Records Retention Act, what we do is we keep them for the mandated 3 years, and after which time it's standard practice for us to destroy the records after that period.
Were you asked to investigate whether you had any records as it relates to an application to become a police officer in Prince William County by the defendant, in this case, George Zimmerman?
Yes, sir.
Were you able to locate the actual application?
No, sir, it was destroyed.
I'm going to show you what's marked as State's Exhibit 211. And do you recognize this exhibit, sir?
Yes, sir.
Okay. What is that?
That's an extract of what we do is after we destroy, you're talking about this first document?
Go in.
Okay. After we destroy the records after the period of 3 years, we create a very cursory amount of information on the record that was to be destroyed. Basic information, name, address, date of applied, et cetera. And additionally, we also send out a letter for those individuals that are not considered further into the process. We send them a dated letter with my name at the bottom regarding their status, and then they're not going to be considered further.
And in this case, what was the date of that letter?
The date was July 8th, 2009.
Now, Lieutenant, I'd imagine you get a lot of people who apply.
Yes, sir.
So is there anything unusual or sinister about just people not getting the job as an officer?
No, sir.
Okay. Thank you. No other questions, Your Honor.
Thank you. Any cross?
And I would move at this time State's Exhibit 211 into evidence.
It'll be admitted. State's Exhibit 211.
Morning, Lieutenant Kern.
Morning, sir.
Your position in the police department is because you're a sworn police officer and have full privileges as such?
That's correct, sir.
Are you currently serving in any kind of investigative capacity?
No, sir.
It's more administrative?
I just recently changed assignments just over 3 days ago. I'm now the watch commander for the Western District Evening Squad. But prior to that, I was with the Personnel Bureau.
So it's not uncommon, I take it, within a given police department to change hats from time to time?
No, sir.
Maybe patrol, maybe investigator, maybe behind the desk?
Yes, sir.
How long were you in the administrative position prior to your current assignment?
6 years, sir.
So you were the administrator then at the time Mr. Zimmerman applied?
Yes, sir.
Do you have any, you have no copy of his application, I take it?
No, sir. It was destroyed.
And you couldn't tell me, for example, who he used as a reference on his application?
No, sir.
You don't have a personal memory of the contents of the application itself?
No, sir.
Because, as Mr. Vanta said, you get a lot of them.
Yes, sir.
A lot of people want to be police officers,
Yes, sir.
as did you, obviously.
I did.
So, if I understand the process then, there is an application, obviously, and then under your records retention policy, after a period of time, the actual record is destroyed and there is a brief extract or excerpt from the application, or from the process, rather.
That's correct.
In this exhibit, which is marked as 211, you are certifying here that you are the records custodian.
Yes, sir.
And that what's attached to it is a business record.
Yes, sir.
I notice, for example, that it's not on letterhead and it's not signed, and it doesn't have any more information on the document other than the actual written contents of it.
That's correct, sir.
So this isn't a copy then of the actual letter that was sent in the mail?
It's not the actual copy that was destroyed. That's the document that was used to create the original, in terms of later my signature was placed on it along with the letterhead.
This would have then basically been the word processing document that was printed?
Yes, sir.
And you don't have a specific memory of reviewing or signing this?
No, sir.
This is just one among other documents that are kept in the system?
Yes, sir.
And then this other page of the document, if you can see it well enough from here, just to help me know what it is this the extract you're talking about?
Yes, sir.
And in this extract, it includes, of course, Mr. Zimmerman's name and social security number and his address at the time. That would be the address at the time he filed the application?
Yes, sir.
The It would indicate ethnicity.
Yes, sir.
It would indicate gender.
Yes, sir.
Is that what that means, G?
I'd have to, some of them were rather abbreviated and cryptic. Yes, sir. That's correct.
G would be gender, and then Mr. or would be Mr.
Correct. Yes.
A guy.
Yes, sir.
Spanish,
That would be any languages spoken other than English.
so that it would indicate that Mr. Zimmerman's bilingual.
It would indicate that he stated that he knew another language other than English. In other words, we didn't confirm that, so this is all self-disclosed information on the application, and we just transpose it onto the spreadsheet. So we didn't validate anything in terms of his Spanish-speaking skills. That was self-disclosed.
I see. Well, as would be the birth date, the social, and everything else. Right?
Well, some of those things can be confirmed up front through driver's licenses, et cetera, but Spanish would be an actual test that would be performed later in the process.
I see. Gotcha. And then at the end, there is a column that says COLL, comma, credit history.
Yes, sir.
Do you take that to mean that Mr. Zimmerman had a problem with his credit?
Yes, sir.
And that would be a reason why you wouldn't be accepted as a police officer?
That's the reason why we did not consider him further based on that record. Yes, sir.
It makes sense if you think about it, doesn't it? Because a police officer who has credit problems would be vulnerable to criminals, wouldn't they?
Possibly.
They could be put in compromising situations where they may make a bad decision because of their financial concern.
Yes, sir.
So if somebody has bad credit because of their age and not having a clear established work history or any number of other reasons that shows up as bad credit, he would be, in fact, was rejected.
Yes, sir.
So that would mean, I take it, that when his credit got better, or he was able to fully address that issue to the satisfaction of the department, he could reapply.
It's possible, sir.
In fact, you know of people that have applied once, been rejected, maybe applied again, even with other agencies, and ultimately gotten on.
Yes, sir.
Can I have just a moment, Judge? Thank you.
Yes, sir.
Thank you. Any redirect?
No, thank you, Your Honor. Ask to be excused.
May Lieutenant Kearns be excused? You said yes?
Yes.
Do you solemnly swear or affirm that the testimony you shall present will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
You may proceed.
Thank you, Your Honor. Captain Carter, if you would, please introduce yourself to the jury. Tell them who you are, name, rank, serial number, where you are.
Roger that. Captain Alexis Francisco Carter, United States Army, assigned to 3rd Infantry Division, Fort Stewart, Georgia. United States Officer, JAG Corps.
Tell me what JAG Corps means.
Stands for Judge Advocate General. I'm basically a military prosecutor in the Army.
So you're yet another lawyer.
Yes.
Thank you very much.
Captain Carter, do you also teach courses?
I did at one point, but not currently.
Okay. Would that have included back in spring of 2010?
Yes, I taught a course. Yes.
Where did you teach that course?
Seminole State College.
And what was the name of that course?
Criminal litigation.
Do you remember the defendant, George Zimmerman, being a student in that course?
I do.
Okay. And actually, do you remember what kind of grade you gave him?
I give him a name.
All right. Tell me a little bit about what type of course that was.
Well, when I got the book, or when I got wind of the course, criminal litigation, I automatically assumed that I'll be teaching it from a more practical standpoint, trial advocacy, things of that nature. But the way the course book was set up, it wasn't really like that. In the time frame in which I had to teach the course, I couldn't really teach it from a trial advocacy standpoint. So it was mostly like a crim law, crim procedure course. We talked about the law, elements of the law. We talked about criminal procedure, the constitutional rights, Fourth and Fifth Amendment, things of that nature.
Did you almost do any kind of what I'll call mock trial sort of thing?
Not really. Not in that course. We didn't have the time for it. Again, it just kind of focused on the elements of the crime, and we would go through hypotheticals where we would ask the students certain questions regarding certain cases and things of that nature.
You mentioned your course book.
Sure.
I'm showing you just what's, is that your course book titled Criminal Law and Procedure?
Yes.
Okay. And I'm showing you what's in evidence now been marked as State's Exhibit 210. Is this a sort of subsection, very small section of this very big book?
Yes.
Okay. And that's a chapter specifically pertaining to what?
Self-defense.
Okay. And the second part of State's Exhibit 210 is what?
It's a email homework assignment from George. It was the first homework assignment that I gave to all the students.
Okay. And is that the rest of it actually additional homework assignments?
Yes.
Your Honor, I will move State's Exhibit 210 into evidence at this point.
Are you moving the book or the excerpt?
Just the excerpt in.
Okay, they'll come in as a composite exhibit 210.
Thank you, Your Honor. Talk to me a little bit, Professor, about what kind of student you remember the defendant to be.
As you always kind of remember your smartest student, or the one that stood out the most, the one that probably wasn't the best student, and he was probably one of the better students in the class.
You mentioned that, and we talked about State's Exhibit 210 as an excerpt from the book about self-defense. Obviously, you were teaching this course in Florida, so tell me what sort of things you addressed as it relates to the law of self-defense in Florida.
Right, so the way the book is comprised, obviously the publishers aren't from Florida. They didn't really put Florida-specific things, but I wanted to teach the class from a practical standpoint where these students can really relate and take something from it and apply it to their own lives. With Florida and other states, they have what's called the Stand Your Ground law, which evolved from the Castle Doctrine through case law.
And did you cover that specifically?
Yes.
Did you discuss specifically self-defense and stand your ground laws in the connection of violent crimes such as murder?
Yes.
And did you address the particularities of... Strike that question. Bad question. Professor Carter, what can you tell us about how long you spent as part of that course covering ideas like self-defense and standing?
Right. Self-defense is a affirmative defense. It's a big self-defense. It's not one of those things that you're going to just whisk through in a day, or after you teach it, you're going to neglect from bringing it back into the classroom. So it was something that I constantly iterated. I was the type of professor that before I gave any tests, I gave a review for the test. And it was something that I think the students really wanted to know about. It was so practical that they were very much engaged in class discussion regarding the issue. So I remember, talking about it, quite a few times, not just on one particular occasion.
Thank you, President. That's all the question.
Okay, thank you. Cross?